Personal Property and Bailments, Chapter 20. In this chapter, we're going to define personal property, define bailments, classify them, and then use those classifications to understand what level of care and liability attaches depending upon the type of bailment we are using. In this business law course, we're going to look at transactions between sellers and buyers. The objects that sellers are usually providing to buyers are referred to as goods. Goods are a type of property. So we're going to start the course with looking at how we define property. Property can be defined in two ways, as real property and as personal property. Real property is land and anything permanently attached to land, like a house or a building. Personal property is property that is movable and tangible. Now, we also have intangible rights in property, i.e. intellectual property rights, right to ownership of things we create, but the personal property itself, the type that we're going to focus on, is movable and tangible. For instance, if Samsung is producing cell phones, those cell phones are its property, its personal property because it's movable and tangible, and then we're going to look at how Samsung, the seller, would sell its personal property, which we would call our goods, to a buyer. Another way to hold property is as a gift. Now, ordinary gift between two people requires two things to be consummated. You've got to have the intent to donate the item to the person you're giving it to, and then you have to have delivery. So you have to have the intent to gift and then delivery. That is a way to transfer property from one person to another. If the person receiving the gift or the person giving the gift dies before the delivery of the gift item is complete, there is no delivery. The gift is not complete. We're going to talk about in a minute why we care about gifts. Gifts can also have conditions. You could have a condition precedent, where there's something that the donee, the person receiving the gift, has to satisfy before they can get it. For example, this car is yours when you graduate. Well, there's a condition there. You're only going to receive that car if you actually graduate. So that's considered a condition precedent. A condition subsequent is when there's a condition that must be fulfilled after the gift, or else you lose it. This car is yours unless you drop out of school. Gifts are a way to transfer property, but this transfer does not require any money. It's completely free, and therefore it is not complete. The promise to give someone a gift is not complete and is not enforceable until the gift is actually delivered. Property can be defined as real or personal. Real is property attached to land. Personal is movable, tangible. We can give someone property via a gift, but that gift is not complete unless and until it is actually delivered. But then we can also give a person property and then get it back. And that transaction is defined as a bailment. A bailment occurs when tangible personal property is delivered by the owner, who's known as a bailor, into the possession of another, who's known as the bailee, with an agreement that the property will be returned. That agreement that the property will be returned to the bailor is the contract. So a bailment only can be effectuated using personal property, i.e. movable, tangible. This is different from a gift because the person who receives the property, the bailee, has to give it back. classic bailment is a dry cleaner. Let's take a look. We've got our person taking our dress to the dry cleaners, and when you drop off your dress to get it cleaned, the cleaners gives you a receipt, and that receipt lists the dress and how much it's going to cost and when you can expect to get it back. That receipt is also the bailment contract. The person dropping off the property is the bailor. The person receiving the personal property is the bailee. What are the elements of a bailment? Think of three things: delivery, possession, agreement. We have the delivery of personal property into the possession of another with an agreement that it will be returned. A bailment is a way to transport, move, give, loan, provide property to someone else with an agreement, with a relationship of getting it back. In order to establish that you've actually delivered the personal property to the bailee must be given exclusive possession and control of the property. And the bailee must know and accept the personal property. So you can think of these concepts as awareness and control. In order to establish that a bailee has received property, that personal property has been delivered into the bailee's possession, you must show that the bailee had awareness of the delivery and that they had control of the property that was given to them. Let's look at a few examples. Repair work done on a house. If you have a plumber to come and work on the pipes at your home, is this a bailment? Has a bailment been created between you and the plumber as it relates to your house? I hope you said no, it's not a bailment. Why? Let's go through our elements. Was personal property delivered into the possession of the plumber with an agreement that it would be returned? No. First of all, working on a house is not personal property. That would you'd be having someone to provide a service to you working on real property. So you would with a bailment, you have to have something that is movable that you deliver into the possession of the bailee. That's not taking place here. None of the elements took place here. We didn't have personal property, we didn't have delivery into the possession, and there was no agreement that the home would be returned. So not a bailment. What about taking your car to a mechanic? Is that a bailment? Go through the elements. Do we have the delivery of personal property? Your car, movable, tangible, into the possession of another? You take it to the mechanic with an agreement that it be returned. Most people, when they drop their car off to get it fixed, are hoping to get it back and hoping it doesn't have a huge bill. This would be a classic bailment. Taking your mom's clothes to the dry cleaners is a bailment created here. You're taking your mother's personal property and you're delivering it into the possession and control of the dry cleaner with an agreement that it would be returned. Now, the dry cleaner is the bailee and you are the bailor. Some of you may be wondering, well, I don't actually own the property. Can I create a bailment? Even though our definition thinks of the bailor as being the owner, under the law, the bailor doesn't actually have to be the legal owner of the property. Even though those aren't your clothes you're dropping off, your mother's clothes, you, as it relates to the dry cleaner, are the bailor. You are the party who's dropping off the personal property. So we have a bailment. A coat hung on a coat rack in a restaurant. Is this a bailment? How do you know? You go through the elements. You're looking for delivery, possession, and agreement. Have you delivered personal property into the possession, and I'm going to say control and awareness of the bailee with an agreement that it would be returned? If it's just a coat rack and you go into the restaurant and you put your own coat on the rack, and you are not delivering that coat into the restaurant's possession with awareness on their part from somebody taking the coat, and it's not put in their exclusive control, then there would not be a bailment. However, if you were taking your coat and you go into a restaurant and the attendant at the entrance of the restaurant takes your coat, puts it in a locked room, and gives you a ticket for you to redeem your coat when you return, that would be a bailment. Why? Because in that scenario, you would have delivered your personal property into the possession of the restaurant, and they would be aware of it, and it would be under their exclusive control because they took it and they gave you a ticket, and that ticket, which creates the contract, also establishes their awareness, which is why it's good to get a ticket when you drop something off. That's why you get one at the dry cleaner, when you get some kind of contract or receipt when you take your car to the mechanic. It creates the contract, and it is proof that the bailee had awareness and exclusive control over your property. But in this example of just a coat hung on a coat rack without more is not a bailment. Now let's look at our last scenario. A coat given to a coat room attendant in a restaurant in which the owner of the coat left a diamond engagement ring worth $2,500 in the pocket of the coat. So why are we asking this question? So what's going to happen? Clearly, probably what happened, we're going to make up the scenario. You gave your coat to the coat room attendant. You've got the ring in your pocket. You get your coat back, but there's no ring. And then you become a plaintiff. You sue the restaurant for failure to return your ring. And you probably you may throw in, not only did you fail to return it, but you stole it. It's probably what you're going to allege. Well, the restaurant is going to have a good argument here. They might admit, yeah, maybe there was a bailment between us as it related to the coat, because when you delivered your coat, your personal property, into the possession of our coat room attendant, they had awareness and exclusive control. And there was an agreement that you would get the coat back. But as it relates to the ring, we did not know. We lacked awareness or exclusive control over the ring that was in the pocket. If you did not alert the coat room attendant that there was a diamond ring in the pocket when you gave them the coat, you were not delivering the personal property of the ring into the possession of the restaurant because they lacked awareness or exclusive control over the ring. So, as it relates to the coat in this situation, you've got a bailment. We've got delivery, possession, agreement. But as it relates to the ring, there was not a bailment because the restaurant lacked awareness and exclusive control over the ring in the pocket. We can classify bailments. We've got 3 classifications and groups. A bailment that is for the sole benefit of the bailor. That means it's solely for the benefit of the person dropping the personal property off. Sole benefit of the bailee, solely for the benefit of the person receiving the property. Or mutual benefit of both parties. Let's look at these. A bailment that's solely for the benefit of the bailor. What's an example? This is when you are delivering your personal property into the possession of another, and it's solely for your benefit. For example, let's say you stay in the dorms during the semester, but at the end of spring semester, you have to move out, and you don't want to take all of your boxes and clothes home because you live out of state, and you've got a friend who has an apartment in Greensboro. You might ask that friend, could you drop off a few of your boxes and leave them at their home until you come back for fall semester? That would be creating a bailment solely for the benefit of the bailor, the person whose property it is. Sole benefit of the bailor. You're going to deliver your personal property, your storage boxes, into the possession of another, your friend, who becomes the bailee, with an agreement that it would be returned when you come back for fall semester. Provided that when you drop off the boxes, your friend is there and they see them and they take them from you, then you've got the delivery into their control, and they've got awareness of it. Now, when is that type of bailment solely for the benefit of the bailor? What duty of care do you owe to the bailee for the goods? You have to disclose to them known defects and to inspect for discoverable defects. Okay, what does that mean? That means if you're dropping off things that might be flammable and you know it, you need to disclose it. And that also means that even if you have things that you don't know that they might be flammable, you need to look over your stuff, i.e. inspect it, and make sure there isn't any problem and let the bailee know about it. That's the duty to disclose known defects, things I know about my personal property, and to inspect for discoverable things, things that could easily be discovered if I would at least check over my stuff before I drop it off. Now, what level of care does the bailee, the person receiving my goods, owe me as the bailor for my personal property when it's solely for the bailor's benefit? Well, this is kind of intuitive, but you owe slight care. It's like you're doing the person a favor. You don't have to take your friends' boxes and store them all summer for free, right? If this is for free, you're doing a favor. So under the law, you only owe slight care as the bailee. And therefore, you, bailee, will only be liable for damage that occurs to those boxes if you exhibit gross negligence. Hopefully you can tell by the words gross negligence, that means it's got to be pretty severe. So you do your friend a favor. You take their boxes of storage and books and clothes and keep them over the summer. You only owe slight care. They come back in the fall and they discover that their clothes are stinky and mildewed, and they sue you. They would have to prove, the law provides that they would have to prove that you, the bailee, exhibited gross negligence in order to hold you liable for the damage to their personal property. Now, what's gross negligence? It depends upon the facts and the circumstances. This is an area in the law where we don't define what gross negligence is. Gross negligence is going to be determined by looking at the circumstances, what you put on, what what the plaintiff, what kind of evidence they can show. If the plaintiff can show that it rained all summer and you, the bailee, put the box of clothes in your garage and you knew your garage had a leaky roof and it leaked all summer and you moved your boxes of stuff but you didn't move your friend's boxes, that might be gross negligence. Because they might be able to convince a jury that, you know what, even though you didn't owe me a lot of care, you only owed slight care, you took the time to move your boxes and you were aware of the leak and you saw that it was leaking and you knew that clothes could become mildewed if they were subject to rain all summer and you did nothing. So you might could convince a jury that that's gross negligence and hold the bailee liable. But if you had facts where the clothes became mildewed, there was only one hard rain during the summer, you didn't know as the bailee that your garage had a leak, you had your own things stored in the same garage, so your stuff was exposed to the same elements as the bailor's, then it's going to be harder for the plaintiff to claim you actually exhibited gross negligence. What about if the bailment is for the sole benefit of the bailee? This is also known as a gratuitous bailment. So this is the reverse situation. This is where the bailor is giving the bailee their personal property so that the bailee can use it in some manner, and it's doing a favor for the bailee, and then the bailee has to return it. For example, let's say you've got a classmate who would like to borrow a textbook. Maybe they're taking statistics and you already have a statistics book. And to save them money, you lend your classmate your statistics book. And you expect to get the book back after their class because then you plan to sell it. So that would be a bailment because it would be a transaction where you would be delivering your personal property, your textbook, into the possession of another, your classmate, with an expectation that the book would be returned at the end of the semester. And it's solely for their benefit because you didn't charge them. What duty of care does the bailor owe towards the goods then? You only have to disclose known defects. I'm doing this for your benefit. I'll let you know if there's anything I know about the book. So in the textbook, maybe you'd say, I do know that chapters 5, 6, and 8 have got a lot of highlighting, and so you're going to have to deal with that. And so that's the known defect that you have. You don't have to find out discoverable defects, just things that you happen to know about. So what care does the bailee owe when the bailment is for their benefit? Well, they owe extreme care. And we all kind of exhibit this intuitively without knowing the law. When someone lends us something of theirs to let us use, we typically try to take better care of it than even we would our own things because it's somebody else's. And so the law follows that same kind of rule in that if the bailment is for the benefit of the bailee has to exhibit extreme care over the goods, over the personal property. You have to take better care of it than you would your own things. And therefore, the bailee will be liable for damage even if they exhibit only slight negligence. The third type of bailment is the mutual benefit. So this is when the bailor is delivering their personal property into the possession of the bailee with an agreement that it would be returned, and both sides are getting something out of it. Typically, this is, for instance, when you are paying the other person to do something. For instance, I'm going to drop my car off to get it repaired. You are taking care of my car, but I'm also paying you to fix it. Dry cleaner. I'm dropping my clothes off and I expect to get them back. But why? Because I'm paying you to clean them while you have them. If you had a classmate who wanted to use your textbook and you charged them, and then they were giving it back like it was a rental, that would make it a mutual benefit bailment. Now, the examples I've given you all involve money, but it doesn't have to be money. As long as both parties are getting something out of the bailment, it could be mutual. I lend you my textbook and therefore you do my homework. Don't do that. But that would be a mutual benefit bailment because each party was getting something out of it. Now, that one might fail the test because lending you my textbook is delivering personal property. But you doing my homework is actually a service, so that wouldn't qualify as a bailment. Maybe if the person in exchange lent me their notes, so they gave me their notes and I got to look at them and then give them back, that would be a bailment. And that would be mutually beneficial. You get to use my textbook, I get to use your notes. When we have a mutually beneficial bailment, the bailor has to disclose known defects and inspect for discoverable ones. The duty of care of the bailee is to exhibit ordinary or reasonable care. This is what a reasonable, ordinary person would do. How would a reasonable, ordinary person take care of a textbook that somebody lent them? You don't have to give extreme care, but it's more than slight care. It's what a reasonable, ordinary person would do. And again, how do we define that? It's what the jury would say a reasonable, ordinary person would do under the circumstances. And the negligence that the bailee would have to exhibit in order to be liable is ordinary negligence. If the bailor's property is damaged while the bailee has it, and it was a mutually beneficial bailment, then the bailee would be found liable for the damage if they failed to do what a regular, ordinary person would have done to take care of the property. The last two important concepts I want you to understand about a bailee is that they've got two important rights. One is a lien. Let's think about our mechanic and our dry cleaner. With the bailment, the bailee does not own the property that they receive from the bailor. They are just receiving the property, and they are going to either, use it, store it, fix it, hold on to it for some amount of time, and then they're supposed to give it back. That is the agreement. If it's a mutually beneficial bailment and money was owed, for instance, the dry cleaners, if the bailor, drop my clothes off at the dry cleaners and they clean them and they're waiting for me to come back and get them and pay, if I don't ever come back and pay, what can the bailee do? Because they've already performed their part of the agreement. They've already cleaned the clothes and they've already kept them. Well, that puts them in a bad situation. The law creates the ability for a bailee to put a lien on the property. In case I never come back and pay for the clothes, the bailee has the right to exert a lien, sell my clothes, and then keep the money that they receive for the clothes as reimbursement for their loss. It might not completely cover their loss, but it helps to keep them from completely losing all amount of money. And I'm not sure if you guys go to dry cleaners a lot, but one of the cleaners that I've gone to will actually oftentimes have a little rack inside the store where they have clothes for sale that people have never come back and picked up and paid for. How can they sell those things even though they don't own them? Because the law provides that a bailee has the right to assert a lien on property that is in its possession in order to compensate them if the bailor never returns and pays for their goods. And you often have these kind of liens for lots of other transactions, service providers, mechanics, liens, where people, to help make them whole when they've already done what the contract called for and there's no way to get compensated. The bailee also has the right to limit their liability in the contract. A bailee has the right to put the bailor on notice of what they will be responsible for. So think of the example of a parking garage. When you buy a ticket to go into a parking garage, you are delivering your personal property, your car, into the possession of the parking garage with an agreement that you will get your car back. The parking garage on the ticket will typically put some contract language that spells out to you what they will be liable for. And typically they're saying we will not be liable for loss of valuables that you leave in your car. Take them with you if you want them to be safe. We are not responsible for stolen items out of your car. So that is their way of limiting their liability. Why? The law allows them to do this as long as they put you on notice at the time that you enter the contract. And in this instance, the contract is that ticket that you receive. And if you read those, you will see the limitation of liability. And this is another way that bailees can limit their liability for care over the bailor's goods.